First of all, I want to say thank you so much for being able to join me on this interview. And thank you for the opportunity. And I'm so glad. Can you kind of talk about your office just so, I mean, I've been talking to you, John, for so many times already as far as probate. I really appreciate all the help and the advice that you have given me so far for doing probates as well as. Want to talk about a little bit about your office, John?
Okay, well, we've been in business since 1976. And before that, we worked at like a legal aid for 4 years in Boyle Heights on Brooklyn, uh, right close to where I grew up. So,
Oh,
uh, okay, most of our practice right now, probably about 90%, has to do with estate, wills, trusts, probates, conservatorships, the preparation of wills, trusts, and of course, we do a lot of litigation uh, because people are always unhappy with inheritances, how it's going to be distributed. We also have been probably, at least for the past 20 years, under contract with the Mexican consulate
uh-huh, uh-huh.
to represent people that
Mhm.
die in Mexico and leave property in the United States, or people die here, but they leave a lot of beneficiaries in Mexico.
Got it, got it.
So we have an office here. We have an office in Santa Ana. There's another consulate in San Bernardino, another consulate in Oxnard. These are the ones in this area, you might say.
Got it.
So we have Mexican attorneys that work for us, but they're in the consulate's office, interviewing people and directing them. We also have been involved in a lot of, it's called landlord tenant, but we have represented many tenants against landlords for inhabitable conditions. Most of them have come from the consulate, but other people come in, in referrals. We once represented 100. It's called a mariachi case. So we're in Boyle Heights also, where we represented more than 100 tenants that lived in this dilapidated property. So we've done hundreds of seminars also with respect to estate planning, wills, trusts,
Okay.
for banks, title companies, brokers, the consulates. That's basically our practice.
Okay, wonderful, wonderful. All right. So, based on this, the reason why we had this interview is really I've my past clients and so as the other people have been asked so many questions in reference to probate. Being that with COVID hitting us now, some of them are like left where so surprised of what are we going to do now, and especially that most of them they think like, okay, well, we have a property is fully paid. However, mom and dad passed away, and we want to sell it, and especially that the market is so great right now, they left were not really knowing exactly what to do. So I want to dive in with some few questions. I don't know if you were able to review the questions that I had asked you, that I sent you. So the biggest question would be, what is the biggest mistake that you see for personal representative making when they try to settle an estate alone? What is the biggest mistake?
The mistakes are countless, and not only improper or persons that are trying to represent themselves, but also attorneys that don't have a lot of knowledge of how the probate process works, because it's like a specialty. I mean, any attorney can do it because that's we have a license to practice law, but it's really a specialty that requires knowledge of the process. I think in most courts, the judges will advise persons that don't have an attorney that they should retain an attorney, because the process is kind of technical, complicated, and the thing is that unless you do the things the way they have to be done, then there's going to be delays, because it's going to be every time you get to court because there's defects, and the defects causes delays, especially now. I mean, the delays are in months, if not years. So that if you didn't do everything proper, instead of maybe 1 year, maybe the state is going to take 2 years, 3 years, 4 years, or longer, because the mistakes are not corrected. Probate is probably it's the only practice in court where they have attorneys that review everything that's filed. There's maybe about 20 probate attorneys that work for the county, and anything that's filed has to be reviewed by these attorneys. And unless it's okay with them, you're not going to get to the judge.
Sure.
And that's what causes the delays. It's not that you can't learn from your mistakes, but that's the biggest problem that I see from persons representing themselves. And sometimes they come here after they tried for a year, 2 years, or other problem. Either they don't know how to start, or they don't know how to finish, because the finish requires what is called an accounting, and the accounting takes certain steps that have to be done. It's not only, probably the biggest problem that the courts face throughout all the probate courts that we go to, like we go to Santa Ana, we go to Riverside, we go to San Bernardino, LA, of course, is the accountings. In other words, and the accounting is at the end, and a lot of attorneys have a problem with that, because we're not trained to be accountants. And then, of course, the persons that represent themselves have even a worse problem. So those are the things. I think it's the process that can delay the process more than anything else.
Okay, so if in essence, in short, what I'm hearing from you, just in clarification, just so some people don't understand what's prepared, meaning that this are personal representative that represented themselves. And then what I'm hearing from you is finding out after about a year or two that they really have to hire an attorney to be able to work this. And the problem, what I'm hearing, what you said was the accounting, right?
Well, that's one of the problems, but there's other things. In other words, there's process, there's things that have to be done. And unless they finish with step 1, they can't get to step 2. And unless they finish step 2, they can't get to 3 and 4. In other words, there's things that have to be done, notices that have to be sent to different governmental agencies, to heirs. You have to look sometimes for beneficiaries and heirs. You have to do things that follows the law. And unless you do them, I mean, you're going to be knocked back all the time.
Okay.
Some judges are more compassionate to persons that represent themselves, and some are not.
So how long does it usually take to close an estate in probate? Do you have any idea typically?
Well, okay, if it's a simple probate, in other words, not going to be any problems going in and going out. Right now, probably it's at least a year in Los Angeles, and the minimum time that we could probably close it, if we could, would be 6 months. But because of the delays in courts, it's going to be well over a year. And if there's delays, then it just keep going. It's like right now, if you file, say, like the final account, everything is final. okay, we file it today, they're probably gonna give us a date maybe in September. So
Oh,
it's not gonna be tomorrow.
got it.
So if you, it's like, I was in court last week and some people wanted to object. Well, the court said, see if you could work it out with Mr. Ramos. But I mean, the thing is, if you object and you want a trial, maybe 22, maybe 23.
Oh.
So nothing is going to work, with any degree of speed. Orange County is probably worse. You get into San Bernardino, Riverside. I mean, the delays are even worse.
More longer.
Yeah. So if somebody was going to start a probate, they should seek an attorney that does probates. There's a number of them in all the courts. And yeah, that's what I would recommend. The other alternative to try to avoid probate is to have a trust prepared.
Right.
That sometimes avoids, well, the purpose of a trust is that it avoids the probate.
Right.
But unfortunately, probably half the courts in probate right now have to do with trust.
Right.
Because now we have to litigate that somebody doesn't want to close the estate. They don't want to do accounting. They don't want to sell the property. They don't want to do anything. So we're back in probate, the court that we were trying to avoid.
So in essence, would you agree that, no matter how big of what your assets are, whether you own only one property or two or more properties, you simply will suggest to have a living trust, correct?
Well, I don't suggest anything. What we do is try to give them the difference between a will and a trust.
Okay.
This has to go to court. It has to proceed to court. This other document is similar. It's not exactly the same, but it's the purpose is the same. In other words, that at the end of the road, you want property distributed through a trust because it would avoid having to start the probate. But like I said, unfortunately, because it's the same people that are upset with each other, that don't see eye to eye, there's going to be litigation, unfortunately, with respect to trust as to who should be the trustee, whether that property should be sold, whether it should not be sold, and other things that have to do with the management, you might say, of the trust. The thing is, even though it's a trust, it's the same requirements as if you were in court. The trustee has to do the same thing that the executor or administrator in court has to do. It's the same process. The only difference is they're not in court.
Right.
So they don't have the fees that they would have to pay in court. But it's the same, a lot of, especially brokers, I found out, tell these people, well, they don't have to do anything. You just sell the property. Well, that's why there's a lot of litigation, because you have to follow the same steps. You have to get the appraisal. You have to send notices to governmental agencies. You have to get a federal ID. You have to do the same things that we do in probate.
Right. My question would be, what's the difference between a will and a trust? Because some people say, oh, it's okay, I have a will, I can do a will.
Well, that's up to the person. In other words, they can, the will has to be probated, has to be filed in court. The trust is you try to manage the estate outside of court. So that's the difference. In other words, one is supervised by the trustee and one is supervised in court by the court. 80% of the people that die, they die intestate. So they die with nothing.
Right.
So, I mean, it's a lot of talk. I have a will or I have a trust or I don't have to do anything. Well, that's the people's choice.
Right.
What they should do is they have to sit down with an attorney that does the states and trusts and what have you, and try
Uh-huh.
to get an understanding as what is best for them. Maybe in some cases, the will is best because the children or the beneficiaries are always going to be fighting. So maybe it has to be supervised by the court, to oversee that. Other people, I mean, a trust might be better, as long as, there's not a lot of problems.
So it goes to the question now that I have, where what if the heirs cannot agree on what to do with the property or the real estate property? What happens with that?
In most wills and trusts and that we prepared, most attorneys prepare, they don't specifically say, although I had prepared one last week that says that the property is going to be sold and the proceeds distributed equally among the beneficiaries. Most, including whether you're in probate or in administering a trust, I think the law presumes that there's going to be a reasonable time that you either sell the property or you distribute it to the beneficiaries.
Got it.
And that's one of the main lawsuits that we file against trustees because they don't want to do nothing. They don't want to sell the property. They don't want to do nothing. And we also against administrators or executors that they don't want to do nothing.
Got it.
Either, especially if they're living on the property, they especially don't want to do anything.
I see. So what happens when can they actually sell this real estate before the probate closes?
Okay, what I found out is in most cases, people don't want a piece of a property. They'd rather have the cash.
Okay.
So in most cases, probably 99% of the cases, the properties are sold during either the probate administration or the trust administration before it's closed. So that when we get to the end, we have enough money to pay everybody. The attorney, the administrator, executor, the taxes, everything. And then we distribute the balance, based on who the beneficiaries are.
I see.
So in most cases, we sell the property during the process.
Okay, and so the question that I have also is, what happens if there are more debts to settle than the asset? What happens with that?
What happens, you do the best you can. In other words, we just opened one case where the person that was just appointed last week believes that his brother, who was a doctor, probably has more debts than assets. He owes the government hundreds of thousands of dollars, and it's probably going to eat up most of everything. So the cases are exactly how the people left them.
Yeah.
In other words, a lot of the people have a lot of debts, more debts than they have assets, and that's the way it is. A lot of beneficiaries believe that the debts are buried with the people, but they're not. We bury the people and the debts are on top. So that our job is probably just to try to settle up with these people and just close out the life of the person.
Got it.
So leave it and forget about it. And then the creditor has the option of filing a probate and seeing if they can do it.
I see. Okay. But also it comes to a point where when you initiate, so the steps would be here, just so very quickly, you, when there's a death, if I understand this correctly, walk me to the process. When someone dies, right? And there's property that is involved, right? And so what happens when someone dies? Walk me through that process, just so they understand. When somebody dies and they want to sell the property and there's no will, there's no living trust, so it goes to probate, right?
Right.
Isn't that the case? So then the attorney, the family member now meets up with the attorney and initiates the probate. And what timeline are we looking at that? From the filing to the process of the probate.
Say you file today a probate.
Okay.
Then Probably you're gonna get a hearing in Los Angeles, maybe sometime in June, somewhere out there, okay?
Sure.
And assuming that everything is done that is required, somebody will get appointed in June. If there's defects, what they call defects in probate, or something was not done that was required by the court, it's going to be continued maybe another 2 months.
Okay. So
And
now on the 60 days.
yeah, it's gonna be continued until you get to step one, until you get to the appointment. In other counties like Orange County, it's probably gonna be continued 3 months. Riverside, San Bernardino. I mean, the period of continuance is longer down the road. Then I mean, I just had one they're trying to get us to substitute in Orange County. It's been 2 years and they haven't, because there's dispute between who should be appointed, but it's 2 years.
Wow.
But assuming after somebody gets appointed, okay, then the court appoints what is called a probate referee, which is an appraiser. And then they have 90 days to appraise whatever you want appraised. You cannot sell a property. If you're talking like in your case, you want to sell a piece of property until you get the appraisal. Then, of course, we have to deal with the lender. In most cases, we have a lender that either knows or doesn't know that the mortgagor or decedent has died. And in many cases, we find that they're in arrears. So we have to see about stopping foreclosure or something like that. We find that in many cases.
Okay.
Or we have a beneficiary, maybe under the law now, husband, wife, children, relatives that live in the property can try to negotiate an assumption with the bank.
Okay.
That's possible now, because banks before when didn't want to do that, but now it's kind of forced upon.
Right. On the assumption, obviously, it's the same thing as going through applying for a loan to make sure that the beneficiary is qualified to take over the assumption, correct?
No, it doesn't require qualifications.
Okay.
They just, if they're a relative or somebody named as a beneficiary in the will, the banks have to accept the assumption. That's all.
Okay. So there's no requirement on that for the assumption?
Well, the banks are going to make requirements that and you're going to have to fight with them sometimes, but there's no requirements with respect to assuming the loan. Sometimes you might have to get into litigation with them. We've gone to litigation with many banks over the past years over either foreclosures or assumptions or so sometimes we have to fight with the banks too. But that's part of the process.
So when, as far as the fee for an attorney to do like a standard, like I mean, there's no such thing as a standard probate, but customarily, isn't that true that there's a set fee from the court that you attorneys will be paid for? What are the fees involved when you're doing a probate?
Well, it's not the court doesn't say it, the law sets it. The court just follows what the law, but it's a percentage. It's 4% of the first 100,000, 3% of the next $100,000, 2% of the next $800,000, 1%. It keeps going. It's almost like a real estate commission, except it's based on value. Then, in addition to that, there's what is called extraordinary fees that the attorney or the personal representative can charge for extra work. If there's litigation, there's going to be extra fees.
Okay.
If you have to sell a property, there's going to be extra fees. And in probate, I mean, there is a lot of litigation, either by beneficiaries, by creditors, by someone who's not happy, and that's what happens.
So truly, in essence, what we're talking today is that really we all have to be prepared in for our family and to make sure with a little bit of money spent on a living trust, you would you say that it's important to really do your living trust, correct?
Well, I would say that they should do uh, the, prepare something that will protect their family. If they feel that it's the trust, then they should go ahead and do it. If they
Mm,
feel that it's the will, then they should go ahead and do that one.
mm.
The problem we find is that very few people do anything.
That's right. That's so
So I mean, it doesn't, because we've given seminars to gobs of senior citizens, and they, in other words, people just don't get around. They run out of time. That's the way I figure it. They either get ill, they get sick, they forget things, so that again we can't prepare any documents that happens. Call all the time. Oh, my mother wants to make a will. Well, okay, yeah, I have to go see her. I see her. Well, she doesn't remember nothing, or she doesn't,
yeah,
or he doesn't. Well, it doesn't. But I know what they want. Well, it doesn't matter.
right.
So they have to be competent when they prepare the documents. So unfortunately, that happens many times, and I would say that they should investigate, look into it, do and just proceed on getting something done,
Yeah.
either here, there, or wherever they prefer. But like I said, what we've seen is just people are not ready, I guess.
Yeah, exactly. All right. Well, I think I don't want to spend too much of your time. I really appreciate you giving us a lot of information. We wish that, I guess in the future you give us a little bit more of your time. This is really trying to help people, with not really knowing what to do, especially with what's happened. I did thought about this because I see that a lot of some of the clients that I have been caught off guard where a family member passes and then they want to sell the property. It's a good
Yeah.
time to sell the property. And unfortunately, he has to go through probate with a long period of time, which is 1 year minimum, like what you said. So thank you so much for spending this time. And I will give a post on your information and be able to, talk to you, ask you how much would it cost really to do I know there's no set fee for doing a living trust, and they could give you a call.
Okay,
Any,
sure. That's right. We've given seminars for brokers and, like I said, with their clients and title companies, banks. Everybody wants to provide as much education as
yeah,
possible.
would love,
Yeah.
would love to do that.
But uh, that's we have brochures too that we pass on. But if you want that, you could just check with John. You can coordinate it.
Absolutely.
Uh,
Thank
uh,
you. Thank you. Thank you very much. I don't want to take too much of your time. I know you've given us a lot of information. I really appreciate this. Okay.
okay.
And
Have a good day.
thank you. Have a good